At certain moments, civilization changes quietly, not through armies or crowns, but through a society learning how justice should act. Across the British Isles, that change unfolded slowly, shaped by conflict and reform, giving rise to a legal tradition that would go on to influence the world. In 1166, in the reign of Henry II, the Assize of Clarendon reshaped the very foundations of English justice. At a time when local customs varied wildly from village to village, the king issued reforms that established a new structure: juries of local men sworn to report crimes, royal judges travelling the country to hear cases, and formal procedures to replace arbitrary practices. It marked the beginning of what would become the jury system, ordinary people playing a central role in determining the truth. It also strengthened the idea that justice should not depend on the whims of a lord or the traditions of a manor, but on consistent rules applied across the realm. In 1215, on the water meadows of Runnymede beside the River Thames, another turning point unfolded. A reluctant King John sealed a charter after months of dispute with powerful barons. Its clauses were practical responses to grievance, limits on royal taxation, protections for property, and rules about lawful arrest. Yet the principle beneath it carried extraordinary weight. The sovereign was bound by the law. No ruler could imprison without reason. No authority could act without justification. Though many provisions were quickly ignored, the idea endured. Magna Carta became a touchstone for later generations seeking fairness and restraint, a reminder that power must answer to something greater than itself. Across the 13th and 14th centuries, a more subtle evolution continued as judges of the realm travelled from shire to shire, hearing disputes and recording their decisions. These records formed the early common law, a body of precedent shaped not by abstract theory, but by real lives and real conflicts. Each judgment added a thread to a growing tapestry of principles: property rights, obligations, remedies for harm, protections against fraud. Over time, this accumulated wisdom became a living memory of justice, a tradition built case by case, steadily binding the kingdom together with shared rules. In 1275 and 1285, under Edward I, the Statutes of Westminster marked another decisive shift. These acts codified large parts of criminal and civil law, defining offences, clarifying remedies, and strengthening the role of the royal courts. They limited abuses by local officials, regulated contracts, and laid out procedures that preserved order in an increasingly complex society. For the first time, England possessed something close to a comprehensive legal code. Yet even with these reforms, the common law was not always able to offer relief where strict rules caused hardship. In the 14th and 15th centuries, a complementary system emerged: the Court of Chancery, guided by the Lord Chancellor. It heard petitions from those who could not find justice in the ordinary courts. Rather than focus purely on rigid precedent, it considered conscience, fairness, and intention. This was the birth of equity, a body of principles that offered remedies like injunctions and trusts. It added depth to the legal system, ensuring that the pursuit of justice was not confined to technicality alone. The 17th century brought moments of fierce confrontation. In the halls of Westminster, Sir Edward Coke articulated the bold claim that even the monarch must be governed by the law. His rulings insisted that royal proclamations could not override established rights, and that judges must stand independent of the crown. These ideas carried enormous risk. Challenging royal authority was an act of profound defiance. Yet they laid the groundwork for the constitutional balance that would follow. The struggle reached its most dramatic point in 1649, when Charles I was brought to trial. For the first time in European history, a reigning monarch stood before a court to answer charges of abusing power. The trial was extraordinary not only for its outcome, but for its assertion. Rulers are accountable to the people and to the law. The execution that followed shocked the continent, yet the principle endured. Sovereignty belonged not to a person, but to the nation itself. After decades of turmoil, a quieter but decisive transformation occurred in 1689 with the Bill of Rights. This act limited the powers of the Crown, established that the monarch could not suspend laws, levy taxes, or maintain a standing army without parliamentary consent, and protected the right to free elections and regular sittings of Parliament. It marked the end of absolute monarchy in England and affirmed the supremacy of law over force. The framework of modern constitutional government began to take shape. During the 18th century, as cities expanded and society grew more intricate, the administration of justice continued to evolve. Trial proceedings became increasingly public, evidence was scrutinized with greater care, and the early efforts to professionalize policing took form. In 1749, the Bow Street Runners, often considered the first organized policing group, brought structure to the investigation of crime. They worked under the watchful eye of magistrates, signaling a broad shift from private vengeance to public responsibility. In 1829, under Sir Robert Peel, the Metropolitan Police Service was established. Its principles centered on public consent, minimal force, and transparent accountability. Unlike many policing models across the world at the time, it was not designed as an instrument of oppression, but as an extension of the community. Its purpose was to prevent crime, not merely respond to it. These values reflected the deeper legal philosophy the country had been shaping for centuries. That authority is legitimate only when grounded in the trust of the people. Throughout the 19th century, a series of reform acts transformed the social foundation of British law. By expanding the electorate, reducing corruption, and granting representation to growing industrial towns, these acts reshaped who held power and whose voices influenced legislation. The law increasingly reflected a broader portion of society, laying the groundwork for modern democratic accountability. The Judicature Acts of 1873 and 1875 brought another structural transformation. They merged the common law courts with the courts of equity, creating a unified system where matters of fairness and precedent could be resolved in a single framework. Confusion between jurisdictions faded, and the legal system achieved a clarity that allowed justice to be delivered more consistently. Across these centuries, something remarkable unfolded. A legal tradition shaped not by sudden revolutions, but by the cumulative courage of countless moments. Charters sealed under pressure, statutes written in crowded halls, judges standing firm against kings, and generations refining the structure of justice until it carried both strength and conscience. What endures today is not a perfect institution, but a legacy of restraint, accountability, and gradual improvement. A system that has influenced constitutions across continents and guided nations seeking fairness. A reminder that justice, like history itself, is shaped not in a single moment, but across the long, patient arc of civilization.